How are you feeling this afternoon? Your head is clear? You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether he understands what's going on?
Nothing at all. No.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. At count 7, unlawful use of a two-way communication device as charged. That's a second degree felony. The maximum penalty is 15 years in Florida State Prison.
Promo alert, promo alert, promo alert. Today is your boy NBA King Dave. He bite with another banger. Make sure y'all follow him on Instagram. Subscribe to the YouTube channel. Hit that like button, comment, and let him know I sent you. Hey, he bite with your boy King Jaffa. And this one right here, call you some fine shit. This one right here for the ladies, man. He just in time. Hey, baby girl, you some fine it. Can I hit it? You some fine it. No bull it. Hey, man, check it out. The link will be down in the comment section. Your boy NBA King David featuring King Jaffa. You some fine it.
You a fine chick. You some fine shit. You hella attractive. Got me attracted like a Mac. And I'm a straight savage. You know I got the rat ass looking at dress. You make me wanna cry, but I'd rather have sex. So let a nigga stab it.
What up, gang? I'm back with another video. I say I'm back with another video. Make sure you hit that like button, comment, subscribe. Yes, I said subscribe. Turn on your post notifications. It's free. Do it for me. This your boy Music 101, the street reporter, and I'm back with another video. Let's get into it. YNW Bortlen has agreed to take a plea deal for his involvement in a double murder of him and YNW Melly friends, YNW Juvie, and YNW Sack Chaser. Bortlen murder charge was dropped, and he was charged with accessory after the fact. He was facing 5 life sentences.
So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct?
Yes.
And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first-degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir. What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State you're going to null process count 2 and count 5.
Correct.
As it relates only to Mr. Henry.
Correct.
Okay. So Mr. Henry, what it's going to be is 2 counts of accessory after the fact tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second-degree felony. The maximum exposure.
It's a third degree murder.
It's a second as charged, I believe. It's a third, except as it relates to a capital case. But I'm happy to look it up.
Ours has a third that we discussed. So.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so sir, as to that count, it's going to be adjudication in 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs. I'm going to order restitution payable to Terry Bagley and payable to Ashley Phillips and reservists to the amount. I'm going to give the state 120 days to tell me the amount of that restitution. If they fail to do so within 120 days, there will be no restitution. If they come back with an amount and the attorneys agree on the amount, I will impose that as another condition of your sentence to pay back that restitution. If they come back with an amount and the attorneys do not agree on the amount, I will conduct a restitution hearing.
Since taking the plea, he was given 10 years in prison and 6 years probation. He will get time served. So out of 10 years, he only have to do about 5 or 6 in jail. Before I get into how would this affect Melly and answer the questions everyone been asking or assuming, is he snitching? Let me show y'all what led up to this decision. 2 days ago, YNW Bortlen was presented with an option to take a plea. He had until 1:30 today to accept it or not. But the thing that I realized 2 days ago, Bortlen lawyer came into court shirt bust open, looking like he was just on a yacht with Diddy the night before. He came in with a hangover, allegedly. The way Bortlen stared at his lawyer said it all. At some point, he dropped his head and wiped his eyes. He knew he was doomed. In no way, shape, or form, I would have felt comfortable going to trial with this lawyer representing me. Now, from what I'm hearing, this lawyer is a great lawyer. Maybe he was just having a bad day. Maybe he was just running late. Or maybe he had a hangover the night before. But that day, where that plea deal was presented, the lawyer didn't show up looking his best. In fact, he was stumbling over words and everything. Like I said, to the fact, Bortlen just stared at him while his eyes teared up. Like he just knew, like, going on. It's over. As y'all know, Bortlen don't have a label or money like Melly backing him. So for him to fire this lawyer if he felt that the lawyer wasn't in his best interest and get another one, he can't afford that financially. So taking a plea today was in his best interest. Now, let's get into what everyone is talking about. The judge brought up Bortlen will sit down with the state and give a proffer.
Sir, lastly, and I want to make it very clear on the record, and it's unrelated to this negotiated change of plea, I guess at some point after the fact, the state wants to take a proffer from you or have a discussion with you, ask you some questions about whatever that may be. What I want you to understand, sir, is I guess that's part of this negotiated resolution, but your answers to any of those questions, whatever they might be, have no bearing on me and have no bearing on this negotiated resolution. In other words, the deal you've negotiated is the deal you've negotiated, and that's the ballgame. Do you understand all that, sir? Have you had enough time to talk to your lawyers about all that? They've answered all your questions? You're sure that that's what you want to do? Because I want to emphasize, Mr. Henry, and I'm going to do this again at the end of my plea colloquy, whether you resolve the case by way of a negotiated plea or an open plea to me, or you resolve the case by way of a trial, it doesn't matter to me at all. But due to the resources that have been devoted to this case, I have 250 jurors summoned for jury duty starting tomorrow. So I want to be very thorough with you here this afternoon, because if you wake up tomorrow or the next day and you decide you've changed your mind and you want to resolve this case, both cases, by way of a jury trial, that's not going to happen. All right? If you want to have a trial, the trial starts tomorrow. If you want to accept the deal, you can accept the deal today. But there's not going to be any buyer's remorse, in other words, because I've given you plenty of time to think about this, talk to your lawyers about it, talk to your family about it. I talked to you about it last week. Kind of looks like your lawyers probably did something or other to get a better disposition for you as of this afternoon, but this is it today. So understanding all that, you've had enough time to talk to your lawyers about all that, that's what you want to do. So, sir, has anyone forced you, threatened you, or coerced you into entering these pleas? If I accept your pleas, there will not be a trial in either one of these cases. Do you understand that? If I accept these pleas, there's a whole bunch of constitutional rights you are giving up. I want to make sure you understand all of those rights. You have the right to maintain your plea of not guilty and have a trial in each case. You have the right to present defenses, to file motions and other pleadings in support of your defense. You have the right to remain silent. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to confront and cross-examine the witnesses against you. You have the right to appeal any decisions that I may have made up to this point or any rulings I might make in a future trial. But understanding by entering this negotiated resolution today, you are giving up all of those rights. The matter is going to be resolved today, right now, this afternoon. Is that what you want to do? Are you satisfied with your lawyers? Have you had enough time to speak with them? Have they answered all your questions? Are you satisfied with all the work that they have done for you? Sir, I've got two identical plea forms here entitled Plea of Guilty or No Contest to Criminal Charges in Circuit Court. Each one has your name on the top, your initials on the left-hand side, front and back, and your signature on the back. Did you go over both of these forms? Any questions about what's on either of these forms? And is that your signature on the back of each form? Sir, paragraph 11 of each form that you signed reads as follows. I acknowledge that my attorney and I have reviewed any discovery disclosed by the state. My attorney and I are unaware of any physical evidence for which DNA may exonerate me. In other words, sir, if there's any physical evidence in the case that we could test for DNA, that DNA evidence would not tell me that you were not one of the people in that vehicle when these crimes occurred. But actually the opposite would be true. If there was any such physical evidence that could be tested for DNA, that DNA evidence would tell me that you were one of the two people that was inside this vehicle when these crimes occurred. Sir, do you agree with that statement? State, do you agree with that statement?
Yes, Your Honor.
Defense, do you agree with that statement? Mr. Henry, understanding everything that I have talked to you about up to this point, do you still want to go ahead and resolve both cases today, right now? Defense, is he stipulating to a factual basis for the purpose of each plea in both cases?
Yes.
And if he's entitled to a PSI, defense, are you going to waive that as to each case?
Absolutely.
State, is there anything else that you need me to do before I take his plea?
No, Your Honor.
Okay. So, Mr. Henry, again, two cases. We're going to do one at a time. In case number 19, 1871 CF10A, as to count 3, accessory after the fact to murder in the first degree, and as to count 4, accessory after the fact as to murder in the first degree. How are you going to plead, sir? Guilty, not guilty, or no contest? In case number 23, 10643 CF10A, as to count 1, tampering with a witness in a capital felony, and count 7, unlawful use of a two-way communication device. How are you going to plead, sir? Guilty, not guilty, or no contest? I will accept your no contest pleas as to each. I'm going to find a factual basis to support each based upon my review of each electronic probable cause affidavit as well as your stipulation in court here today. I'm going to further find that you have freely, voluntarily, and intelligently waived your rights, that you have knowingly entered each plea with the advice of competent counsel who you've told me that you are satisfied with, that you understand the nature of the charges and the consequences of the plea. Accordingly, and pursuant to the negotiated agreement, I will sentence you as follows. In case number 19, 1871 CF10A, as to count 3 and count 4, I will adjudicate you guilty, sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation.
For those who don't know what a proffer basically means, he will tell them what he knows about this case. In return, he locks in the plea deal like he did today. Now, as of right now, he haven't did the plea deal. He will do it later on down the line. Now, Bortlen can go in there and tell them the truth, or he can go in there and tell them lies. To be honest, I don't see him giving up Melly. Y'all have to remember, Bortlen is charged with accessory after the fact, meaning he was only involved after Juvie and Sack Chaser was killed. So he can go in a proffer meeting and say Joe Blow, who recently died, called him after he was dropped off and told him come outside. Juvie and Sack Chaser just been shot in a drive-by. And he drove off and took him to the hospital while Joe Blow ran down the street and got into another car. Remember, Melly is saying he was dropped off before Juvie and Sack was killed. He was at home in bed. Last time he seen Juvie and Sack chasing them, they dropped him off and they was alive. This is what Melly is saying. So Bortlen can put this on the dead person of being the last person that was seen with Juvie and Sack Chaser. And mind you, if Joe Blow is dead, he can't be charged. Gangster Williams' Birdman brother did the same thing, but he told on dead people to get out of jail after already being sentenced to life. So I honestly don't see Bortlen telling on Melly. And the judge basically told him, what you say in your proffer has nothing to do with him or the other case. The proffer is solely for his plea deal. Now, if Bortlen put the murder on someone else, Melly lawyers can use Bortlen proffer and tell the judge, look, Melly co-defendant already confessed that Joe Blow was the last person in the car with Sack and Juvie when they was alive. Joe Blow called Bortlen, pulled up to his house after they dropped him off and said, hey, we just got into a shootout. Sack and Juvie just got killed. But while the snitch allegations was going around, Bortlen attorney addressed social media assumptions and said, I don't represent snitches. He will not be cooperating or testifying in YNW Melly trial. Anyone who claims different has not seen the plea deal and has no idea what they're talking about. So after reading that, the proffer can solely be on Bortlen role in accessory after the fact. Y'all get in the comments and let me know what y'all think. Kodak lawyer chimed in also and gave his opinion. Like, comment, subscribe, turn on all post notifications. It's free. Do it for me.
All right, let's get to it. Let's talk YNW Bortlen and YNW Melly. The information is coming in fast and furious to my office. People are calling me left and right. They saw the post. You know what time it is. And they are telling me that YNW Bortlen is not going to be a flipper, and he is not going to be the cheese eater I previously said that he could become. And he is going to give a statement. I don't know what that statement's going to be, but his attorney is an excellent attorney. He's one of my good friends and you know, really helped me out as a young attorney. Fred Haddad, a great guy. And he represented very, very few, if any, flippers in the past. That's why I was kind of surprised at first. But it turns out, the rumor on the street, YNW Bortlen is not going to be a flipper, but he will give a proffer.
That will conclude that matter. In case number 23-10643 CF10A, as to count 1 and count 7, I will adjudicate you guilty. Count 7 is a sentence of 5 years in Florida State Prison. Count 1 is a sentence of 10 years in Florida State Prison, followed by 6 years of reporting probation. I will impose mandatory court costs in that case as well. I will not impose the cost of prosecution in that case as I just did so in the previous case. Pursuant to 943.325, I will need another set of your prints and DNA. All of these, there is no restitution in that case. All of these sentences, all counts, both cases, will run concurrently, that is at the same time with each other. I will give you credit for all the time that you have served. State, in 19-1871 CF10A, your announcement as to counts 1 and 2.
The state may not announcing a null process to those counts, Your Honor.
And in case number 23-10643 CF10A, state your announcement as to count 2 and count 5.
The state may announcing a null process to those counts as well.
Okay. I think that concludes all the matters. State, is there anything else that you need me to do regarding Mr. Henry in either case?
We just have one moment.
I'm looking at the plea forms. The 23 case, they have 707 days credit for time served. In the 19 case, 1,340 days credit for time served. Mr. Henry, I'm not quite sure how your lawyers managed to do this, but I wish you good luck, sir.
Promo alert today is Wealth Addict Keith. Make sure y'all go follow him on Instagram and click that link in his bio. Want to learn how to build your own online business from scratch?
Always remember, social media is king.
Wealth Addict Keith has a program that will show you step by step how to create a digital product, market it, promote it online, and use AI tools like ChatGPT to get ahead faster. You will also get 50 video masterclasses full of strategies you can learn right away. Remember, knowledge is key. Make sure you go to Instagram and check out Wealth Addict Keith. The link will be down below. Let's go. Hey, do me a favor. Look down right there to the bottom left and hit that like button for me. Hit that like button right there. I appreciate it. Now continue watching. Promo alert if you need promo. DM me on Instagram at music101CEO. $30 for one promo video on my YouTube. $50 for 3 promo videos on my YouTube. $70 for 6 promo videos on my YouTube. And $130 for 12 promo videos on my YouTube channel. Make sure y'all tap in and get that promo if you want to win. Charleston White, Rick Baby, Loose Cannon, and about 8
If I step, I'm the leader of this 8 shit.